right, our next case is Mitchell versus Exo Communications. Ms. LaQuasto, you represent the appellant.
In case I have to read something, ours aren't as good as they used to be. Good afternoon. I'm Wendy LaQuasto. I'm here for Fox and LaQuasto, representing the appellant in this case today, James Miller. He was a claimant in the workers' compensation proceeding. I have two worthy adversaries that represent the two employer carriers in this case, and I would like to reserve 5 minutes for rebuttal. This is the second time this case has been before the court. There was a compensation order entered in September 2006. That was appealed, and this court issued what I call Mitchell 1 in October of 2007. On remand, the JCC entered the second order, which is February 12, 2008, just a year ago today, and that's the order that's on appeal. There are two issues that are raised in the appeal. The second one pertains to penalties, interest, and attorney's fees. And unless you all have any questions on that, I'm just going to rest on my brief on that. The first issue is really the meat of everything, and claimant contends that the JCC erred as a matter of law, and by failing to follow this court's mandate in Mitchell 1 during the proceedings on remand, by failing or refusing to resolve the inconsistencies in the 2006 order that were pointed out by this court in Mitchell 1, and opting to simply reissue a nearly verbatim 36-page order with identical findings and mistakes. In the Mitchell 1 opinion, this court pointed out two areas of inconsistencies, and the first had to deal with Dr. Gonzalez, the original treating psychiatric physician, his testimony. He testified, as this court pointed out, and as the JCC found on paragraph 36 in her 2006 order, Gonzalez said, claimant has a 14% permanent impairment rating, all of which is attributable to the 2001 accident. Then, as this court pointed out in paragraph 56 of the order, the JCC accepted Gonzalez's testimony. Then, as this court pointed out, in paragraph 56, she inconsistently said that it appears that a portion of the 14% permanent impairment rating is unrelated to the accidents. And despite this court pointing it out and telling her that she needed to resolve these, she issued a nearly verbatim order that includes the same findings. On page 39, in paragraph 39 of the 2008 order, identical. Gonzalez said 14% permanent impairment rating solely attributable to the 2001 accident. She does tweak the order a little bit, because I have to say nearly verbatim, it's not. And in paragraph 60 and 62, instead of saying that it appears that a portion of it, she makes a similar finding that it's unclear what portion of that 14% permanent impairment rating is related to the accidents. Claimant submits that the JCC can't simply take something that's clear and say it's unclear and say that she followed this court's mandate. Y'all told her to reject or figure out the inconsistencies, and all she's done is labeled it as unclear and hasn't resolved it at all. The other area of inconsistency that y'all pointed out, and I will say that, and I make the argument in my briefs, Gonzalez's testimony is clear in the record. 14% permanent impairment attributed solely to the 2001 accident. Yes, she has a 20% permanent impairment rating according to Gonzalez, but he clearly says 6 of that is pre-existing, 14 solely attributable to this accident. So there's no CSE to support her finding that it's unclear. The second area that y'all pointed out in Mitchell 1 was Dr. Fiore's testimony. He said that Mr. Mitchell had an 8% permanent impairment rating for his right knee attributable to the 2001 accident, and you pointed that out, and in paragraph 23 of the 2006 order, she says, Fiore says 8% permanent impairment to the right knee. You pointed out in paragraph 22, she said, Fiore said no work status because of the right knee injury. That's the major contributing cause is the 2001 accident. And then you pointed out the inconsistency that the JCC found that the no work opinion was apparently impacted by the fact that Mr. Mitchell also has diabetes, which causes him some problems, and that he suffered 2 subsequent non-compensable motor vehicle accidents. On remand, she didn't hold any other proceedings. She didn't take any new testimony. She just opted to reissue a nearly verbatim 36-page order. And in paragraph 23, she makes an identical finding of fact that Fiore says 8% permanent impairment, right knee, 2001. Paragraph 31, she makes the same finding of fact. Fiore said no work status attributable to the right knee, 2001. She tweaks the order a little bit and says in paragraph 68 that she interprets Fiore's testimony as meaning that the no work status involves the motor vehicle accidents and the diabetes. And once again, claimant maintains, I guess we have to quote Shakespeare or paraphrase him, a rose by any other name is still a rose. And, you can't take somebody's clear testimony and under the guise of interpreting it, make it something that it's not. Just like you can't take a witness's testimony that says the light is green and say, I'm interpreting it to mean the light was red. As I pointed out in my brief, Fiore's testimony is really clear. He says 8% permanent impairment because of the right knee. Major contributing cause is the 2001 accident. He clearly knew about her diabetes and the motor vehicle accidents when he rendered that opinion, and he didn't say that those things were causing his 8% permanent impairment rating or the no work status. So claimant maintains that the reasons that she did not follow, that the JCC did not follow this court's mandate, that she did nothing on remand to resolve the difficulties, the inconsistencies that were pointed out in Mitchell 1, and that what little tweaking she did still is not supported by the record. The reasons that she gave, just like they weren't supported the first time, they're not supported now. So,
Counsel, it seems to me the one area that may be different is, didn't the JCC here reject Dr. Fiore's testimony that the claimant's incapable of performing sedentary work, and I guess accept Dr. Baker's, and isn't that different than the first order?
I thought she rejected Dr. Baker. Dr. Baker
Maybe
was
I've
the
got
one
the
who
name-
gave,
I've got the
Dr.
name
Baker
wrong.
gave 16% and said she could do sedentary, but she's always rejected Dr. Baker. Dr. Fiore, when he first examined her, he did, and through 2004, he did have her on I keep saying her, I'm sorry, Mr. Mitchell. He did, Dr. Fiore did have Mr. Mitchell on sedentary work restrictions throughout 2003, 2004. But if you'll remember the facts here, this man developed post-traumatic arthritis in his knee, and he needs a total knee replacement now. And so when Dr. Fiore gave his opinion, and in fact in 2005, Dr. Fiore put him on no work status because this knee replacement surgery could not be completed because of numerous problems. So although there is evidence in the record that earlier on Fiore had said sedentary, the other evidence...
Fiore said the claimant was incapable of performing sedentary work.
That's what he said in his...
That was rejected by the JCC.
In this order.
And that's why, and maybe I misspoke, and that's what was rejected in this order, unlike the first order. Or maybe I'm wrong about that. Gone back and read too much, maybe.
I guess I always thought that she always, because she denied permanent total, that she always rejected that evidence.
I mean, it's certainly easy for me to be mistaken on that.
No, I'm saying, I don't have I guess I can't exactly point to that, but it was always my understanding that she always rejected any contention that Mr. Mitchell couldn't even do sedentary, and that's in the 2006, and that's why she denied permanent total disability benefits, because he could work. So the question is what remedy do we have here? A JCC who's failed to follow this court's mandate and correct the problems, and reversal and remand. Claimant maintains that that needs to be done very carefully this time, because the JCC has been directed once to fix these problems. She was given the opportunity on remand to do whatever she needed to do to be able to fix her problems, and she did not do that. She didn't conduct any other proceedings, didn't take any new testimony, and she just basically reissued the same very lengthy order. So,
but you're asking us to remand with directions to award PTD benefits, which seems to me to put us in the unfortunate position of having to weigh the evidence.
I think that when you can come to, I think that there's Allen and Urban are precedent that y'all have for actually making awards on a second appeal. So, and I think that the way that you can do that in this case is she had two chances to tell you why this unrefuted testimony of Gonzalez and Fiore was going to be rejected, or that there was something else that would overcome it, and she has failed to do that. And the reasons that she gave are not supported by competent, substantial evidence. And she has to do that. She's going to reject somebody's testimony. The reasons that she gives has to accord with reason and logic, CSE. And she hadn't done that.
Ms. LaQuasto, could we do this? On remand, could we direct the judge of compensation claims to appoint an EMA to resolve the conflicts?
Well, that's assuming that there
Well, there are inconsistencies here.
That's inconsistencies in her order. I'm not sure that there's inconsistency in the medical evidence, which would bring out an EMA.
Well, inconsistencies in her order regarding medical testimony.
Well,
It's okay
I would
to
not
say
be the
that's
person
silly.
to tell
If
you
think
what.
It's silly. I'm just asking a question.
No. And my answer to that is, I always understand EMAs are because there's a conflict in the medical testimony.
Well, there is a conflict in the medical testimony, although we find it in the order because there are inconsistencies within this judge's order. But it is a conflict as to medical testimony, isn't it?
I think the more simple solution to that is...
More simple solution would be just for your client to win. I understand that.
Well...
You know, we could pick the other side, too.
I know.
That's the problem with that.
And that wasn't what I was going to say, actually. Although, you know, maybe you're a better advocate than I am, and I know that's not your role.
Well, I'm just sort of getting to the bottom line here.
But I think that, you know, if there's some sort of inconsistency in the testimony, there's that 2003 FCE, which says sedentary, and there's the 2004 sedentary stuff that Fiore says. I think that if that's inconsistent with what Baker, the rejected doctor, is saying, then the question needs to be asked of Fiore and say, you know, did you change your mind? Why did you change your mind about this? And can he do sedentary work? And I'm not sure that that's an inconsistency that requires an EMA. I'm into my rebuttal, so unless you have any other questions, I'd like to reserve.
We'll reserve the balance of your time.
Good afternoon. Jennifer Haley Gleason for the Appalachia Exo Communications St. Paul Travelers in this case. And I have to ask a question. I'm not sure how you want to do this since there are two employer carriers. We had talked about, I have the 2001 date of accident, so the majority of this is mine, but I did want to obviously reserve some time for Liberty Mutual's attorney. So I wasn't sure how you wanted, if you wanted us to divide up the 15 minutes.
It's your time, and you divide it however you'd like to divide it.
We'll do that, sir.
Decide between yourselves. And as a matter of fact, if you want to let the deputy clerk know the amount of time you'll have, we can put your time up, and when it expires, you'll know, or
okay.
I can help you with it, and we can reserve the time for the other counsel.
Sure, I need 1 minute. Give her 3. Give her 3. Your Honor, Your Honors, in this case, the issue on remand was for obviously the judge to correct or make clear 2 of her issues. it is our position that she, in fact, did do that. She had to clarify the issue of Dr. Gonzalez's permanent impairment rating. In her initial order, she indicates that she accepts the 14%, and however, when she went back in her second order, she took out the language accepting that permanent impairment rating. So clearly, she cleared up that issue, indicating that she was not accepting the 14%. She merely indicates that there is an inconsistency in her mind as to what percentage of that 14% is related to his previous mental issues and the exacerbation of them after 2 of his industrial accidents. She indicates that the claimant did not sustain his burden to show that the psychiatric condition or the aggravation thereof was directly related to either of the industrial accidents. So her second order on page 39 did in fact clarify that she's not accepting the 14%. The second issue that this court had was with Dr. Fiore's opinion that claimant had an 8% permanent impairment rating and was not capable of sedentary duty. She again clarified that confusion. In her initial order, she seemed to accept that the claimant wasn't able to do sedentary duty, or the opinion of Dr. Fiore. In her second order, she clearly states on page 42 that she rejects Dr. Fiore's opinion that he is unable to perform any work, although she does accept his 8% permanent impairment rating. One of the questions you asked co-counsel regarding an EMA, I don't believe that there is any authority for this particular court to request an EMA. I think that it does have to be a party of interest or the trial court. And certainly if claimant felt like that there was a conflict of medical testimony, that's something that they could have asked for at the trial level, or the judge obviously could have, but she chose not to. In your initial order, you indicate that it's not the burden of the employer carrier to provide competent substantial evidence in this case, and indicate that their request, again, for permanent total disability benefits is, I don't want to use your words, is I believe you said, is flawed. The claimant's argument is flawed. In this case, I don't think it's appropriate to ask the judge to award permanent total disability benefits, because those are not the issues that were sent back to the JCC on remand. And in the City of Palm Bay versus DOT, it indicates that the operative remand language limits the issues to be addressed on remand to those specific factual findings which were deemed insufficient in the prior order. Your order indicates that those 2 insufficient items were Dr. Gonzalez's permanent impairment rating and Dr. Fiore's work restrictions. The judge has clearly gone back and changed those 2 issues and continues to believe that she did not find a basis for awarding permanent total disability benefits.
So your view would be that if we disagree with you and think that the findings are still irreconcilable with the resolution, that we need to send it back again and tell the judge to try a little harder?
Yes, sir.
Okay.
Well, counsel, what about the statement that the JCC makes on I guess page 30 of 36 in the order? It says, whether Dr. Gonzalez intended the 14% rating to apply only to the aggravation of the pre-existing condition rather than including the underlying chronic depression and chronic anxiety is unclear, while back on page 20 talks about how Dr. Gonzalez applied a 14% rating, all of which was attributable to the October 4, 2001 accident. It seems to me those are continue to be 2 inconsistencies in this order.
And I'm sorry, what was the second? The first page was page 20? I'm sorry.
Page 30 of 36.
Thank you.
Really the top couple of lines, and then the compare to page 20 of 36 in paragraph 39.
Yes, sir. Let's see.
As I understand the record, it's not disputed that Dr. Gonzalez came up with a 20% rating, 14 of which was attributable to the industrial accident and 8% was attributable to pre-existing conditions. I don't know what the JCC continues to say is unclear at page 30, yet doesn't appear to think it's unclear at page 20.
I believe that she made, because there were two different depositions that Dr. Gonzalez gave. The initial one, I believe, was in 2004. And I'm not sure if perhaps she's relating to a second deposition. She doesn't indicate here, but I'm sorry, I'm not quite sure.
I understand.
I'm not quite sure. I'm not quite sure whether she's indicating between the two different dates of accident, the 2000 and the 2001, or whether, I'm not quite sure what she's relating to, reading the two paragraphs there. Or if it seems to me that she's indicating that Dr. Gonzalez is opining that 14% is attributable to the 2001 date of accident, but she doesn't accept that testimony, is what the only way that I could read it, is that Dr. Gonzalez says that 14% is attributable to the 2001 date of accident, although her considering the testimony from Dr. Roberts, which was claimant's physician from 1987, and the Social Security, Dr. Roberts had treated Mr. Mitchell since 1987 for depression, anxiety, and had given him various medications. He had also signed documentation for Mr. Mitchell to get Social Security disability income benefits in 1998. So it may be that what the judge is indicating is that Dr. Gonzalez testifies that 14% is attributable to the 2001 date of accident, but the judge is not, in taking all the evidence into consideration, is not convinced that 14% is directly attributable to the 2001 date of injury. I don't think that she's indicating that Dr. Gonzalez's testimony is necessarily unclear.
Well, she says that at the top of page 30. She says, whether Dr. Gonzalez intended the 14% rating to apply is unclear, whether Gonzalez intended the 14% rating to apply only to aggravation rather than including the underlying chronic depression is unclear. As I said, when we went back to the hearing on remand, I think it was her. You think she may have left this in from the prior order? Was this verbatim from the prior order? Somehow she didn't remove this language? That's.
Well, I can look.
I mean, I haven't compared. I should have, but have not compared the two orders.
I do have both of them here. Page 30. Let's see. Let's see. I think it's on.
Your Honor, I'm acting as counsel here as I work
Sure.
with you in the order. What is on page, apologize, Terry Saeed for Wausau Insurance. On page 20 is identical from the prior order. The changes in it, and then page 33, almost that whole page is new. I've got it marked as to what all's new and what's not.
Okay.
So your questions.
Page 30 of 36 in the new order, is that new, old?
Page 30 is new, starting with item 61 down through the end of 61. That's all new as to the new order.
Okay. Thank you.
Here it is.
And in any event, it is our position that the judge's decision is based on competent substantial evidence, despite any confusion over the psychiatric issue. There were 6 physical doctors in this case, only one of which indicated that Mr. Mitchell could not perform any type of work, and that was Dr. Fiore. The other 5 physicians, as well as the functional capacity evaluation, all indicated that Mr. Mitchell was capable of returning to sedentary duty, and the vocational expert found jobs suitable to Mr. Mitchell's restrictions within the distance of his home that he could perform. In addition, there is competent substantial evidence to support the fact that claimant had a very significant pre-existing condition, which dated back to 1987. He had tried to obtain SSDI benefits, as I mentioned before, in 1998, totally on a psychiatric basis. And the judge does indicate that one of the reasons she rejected Dr. Gonzalez's 14% was that, the opinion of Dr. Gonzalez that all of claimant's aggravation of his psychiatric condition was related to 2001 date of accident was because this is what the claimant told the doctor rather than this is what the doctor found as a result of his examination of the claimant. So, thank you.
May it please the Court, Tara Saeed again on behalf of Wausau Insurance. I just wanted to add for the record on behalf of Wausau, my client, to clarify in this matter that for the June 26 of 2000 accident, that we're almost a non-party in the claim for permanent total disability because the claimant attorney even notes in their brief that they concede that the right ankle injury, which is a 1% impairment rating, no time lost, no restrictions, the claimant returns to full duty. So we're asking if the court does find that there would be an award of attorney fees in this case, that it would not be assessed against us or the claim for PT, as they've already admitted that they realize that my clients would not be responsible for that. And that's my 1-minute argument. Any questions, Your Honors?
I don't think so.
Thank you.
Thank you. Mr. Costa, you have some rebuttal time remaining.
As I said at the first, in paragraph 39 in both orders, there are identical findings about Gonzalez's saying 14% PRR 2001. The difference is that she says in her second order, as the undersigned stated in the previous compensation order, at least a portion of that rating is attributable to complaints which are unrelated to either of claimant's industrial accidents. That's not supported by CSE. His testimony is clear. She can't say, I said it in the prior order, and that makes it true. You know, she's got to have evidence in the record to support what she's saying, and she doesn't have it. As for Dr. Fiore, you know, the only way that she changes that is saying she's interpreting his evidence as saying it includes the no work status includes the motor vehicle accidents and the diabetes. But his testimony is clear. She can't just say, I'm interpreting it this way. As I said, red light, green light. You can't do that. PTD is the issue. That's what it was all about. We came up here on the denial of a PTD claim. We made all sorts of arguments saying that the PTD ruling wasn't supported by CSE. Y'all had a problem with that, and you remanded it back. If you're not going to award my client permanent total disability benefits here from the bench, then I think you really need to give this woman, this JCC, really specific instructions, because the last opinion didn't do it. And, you know, my client has been, he was injured in 2001. And, you know, here it is 2009. This is an ongoing case. You know, since the first appeal was presented in 2000, the first order in 2006, here we are 2009, and he still hasn't been given the benefits that I feel he deserves. And so y'all need to be real specific if you're not going to just award based upon the evidence that's in the record, so that she will get it right the next time. If y'all don't have any other questions, I'm out of time. Thank you.
What's your response about the attorney's fees from Wausau?
I'm sorry?
What's your response about the attorney's fees from Wausau?
I'm sorry. I guess I was preoccupied, and the question is, what she said, that
The attorney's fees
Oh,
for
why?
Wausau.
why attorney's fees shouldn't be,
Right. What's your response to the argument?
well, I'm not sure that there was any thing in a filed response to the motion for attorney's fees against both of them. And if she's, I guess,
But you heard the argument that was made a moment ago.
I did not. Well, that's what I was saying.
Oh, you
What the
did-
question
you
was.
didn't hear the argument?
That's what I said.
Well,
It was.
You can't very well respond to it, can you?
That's why I said.
All
I
right,
guess I was.
Thank you very much. Thank you all.
I don't really care who pays my attorney's fees. I just care that they
I
be
know
paid.
you just want the money. That's fine.